Ms. Sencer?
The current system basically builds in 2 weeks of unnecessary delay in most cases. When asked if briefing is allowed, the regional director usually says yes. That would generally be 7 days. I'll say opposing counsel because it's rarely union counsel that's asking for it in these cases, says, can I get an extra week? And depending on the length of the transcript, that extra week is granted. Then, that's before the regional director even then gets started working on the DDE. Once the DDE is issued, it has 25 days built into it before we have the election scheduled. So simply by going to a hearing that's going to need a decision to be issued, we've added in 39 days into the process, which in some ways just accounts for these numbers from the board's website that indicate that if there's a contested case, it's generally around 66, 65 days till we get to election from the date that the petition is filed. But really, all but the most complicated cases, which really don't need this kind of briefing, I hear what Mr. Kishner is saying, and I understand that people would like to be able to brief all of these out each and every time. But when it comes down to it, the supervisory status that he's talking about, he himself has litigated many, many times. I have litigated many, many times. The standards are written out very clearly in the board's procedures in the outline on representation handling. So there's a list. You have to know which issues you have to hit because that guidance has already been provided. And since hopefully the reader of the record is reading the record, they will see that testimony and without us needing to provide those actual citations to it, because presumably the entirety of the record is going to be read by whoever is writing this decision. And from that point of view, the oral argument is not a particularly high standard to be reached in this. Coupled with a statement of position, which basically would form the outline for management side's closing argument or their closing brief later on, and the narrowing of issues through the hearing, it's really not that much left to be argued and not that much to be briefed. And when you only have a few issues, and they are the same kind of issues that come up regularly, there's really no reason to add this extra time in simply to allow for a closing argument that frankly winds up rehashing the opening argument and in many cases the closing summary provided by management. I frequently argue my cases orally. Do it for a lot of reasons, but one of them is because if you have workers in the room, they like to know that it's being resolved and that you understood their issues. The unions like it for that reason as well. I presume management would like it for those reasons as well, that their counsel understood the issues that they had with the unit. But we do it orally. The representatives of the employer give an oral closing also at the same time, because I don't know why. Maybe they don't want to be outdone. Maybe they feel the same way for their client. Whatever the reason may be, they give an oral closing. And then they give a written brief afterwards, sometimes up to like 30 pages after a one-day hearing, that rehashes all of the background of what the employer does and every tiny little bit of testimony and cites to the record extensively. I don't think it's necessary, and it leads to unwarranted delay. It adds to the work of the regional director when they finally get around to writing the decision, because there's more information for them to go through that may not actually help to make the decision, which in these closed cases is based on the testimony of the individuals and not the arguments of counsel anyway. Regarding this issue on the direction of election and decision, we know in some cases what the decision is going to be. I had a case that petition was filed in late January. The employer asked for the extension and got an extension for a week for the pre-election hearing. The employer then said, I'm not going to be available for that, so I'm not going to show up, but I'm not going to stip either. The union had to put on a hearing with no one on the other side because, under the current rules, the region was not allowed to simply take it as an offer of proof. We were then provided the opportunity, if we wanted it, to write a closing argument. We declined. We did an oral closing based on our offers of, on the witnesses that we had presented. So we pretty much knew what this unit was going to be. It was a single classification. It was a presumptively appropriate unit. It took about 3.5 weeks after the week that was given for us to do the closing, to provide a closing argument, for the regional director to issue a decision. As a result, in a case where the employer did not show up, it still took 67 days to get to election. That, to me, is not reasonable. It's somewhere between a contested and an uncontested case, but there was no reason why the decision couldn't wait and the direction of election issue earlier. We knew who was going to be able to vote. The region, when we asked them about it, simply said it was taking time to tweak the decision, that the people who they needed to consult or going back and forth to the regional director with writing the decision weren't available at all of those times in between. And as a result, the employees are the ones who suffered and had to wait to have their election. That's why we support change.
Thank you. Questions?
Ms. Sencer, our task as an agency is to try to, I think, do three things. One is we want to be prompt. We want to have the correct outcome. And we also want to do what the statute says we have to do. All three salutary objectives. The question I have is, for a moment, I'll just exclude the extension issue because we could address that separately. And I'll exclude the 25-day deferral. And if we're talking about the 7-day post-hearing briefing, and our statute says the hearing officer is not allowed to decide issues, and curiously, it even says hearing officers, at least in pre-election cases, aren't even permitted to make recommendations. So we're stuck with a record of some kind, and the regional director has to make the decision, and without a post-hearing brief. Exactly how do you think, I'm asking you to interpret our own proposed rule, how would our proposed rule work? And is it really worth it to dispense with a post-hearing brief? Because I think that just leaves the alternative of every regional director in every case has to just read a cold record without the recommendation of someone else and decide based on that. So it strikes me, if we want to be prompt and get the right result and do what the statute says, isn't a post-hearing brief, if it takes 7 days, which both sides can file, isn't that better than just throwing a cold record, all of these cold records, at the poor regional director who has to just then decide the cases?
Well, I think nothing prohibits oral argument on this, and that does change the nature of the information that's provided to the regional director. Second, the way that I read the proposed rule, there's nothing that limits the employer's ability, other than maybe their time constraints, from filing a pre-hearing or providing at the date of hearing a post-hearing brief that they would provide as an offer of proof that would go into the record that would highlight some of these technical difficulties or specific legal issues that they otherwise are looking at. And if I can, I want to address this issue of the hearing officer making the recommendation. In the regions that I practice in, whenever we have a dispute about whether or not something should go into a record, we get paused, the hearing officer leaves the room, consult with someone in the back, and they come back and they say, the regional director says this is what's going to happen. So those decisions are not being entrusted to the hearing officer, they're being made to the regional director after the presentation by the advocates to the hearing officer.
But would you agree the statute requires the regional director to make a decision based on the record?
Yes, and that's where that whole issue about offers of proof comes in, to what can go into the record instead.
Would you say, have you had experience where post-hearing briefs are not filed?
I don't recall any cases where the employer has chosen not to file a post-hearing brief.
Mm-hmm.
I know that I have only in very few cases filed post-hearing briefs. And those are not your run-of-the-mill supervisory status community of interest cases, but more like the ones that I was talking about this morning, contracting and expanding the unit. The contracting and expanding unit kind of cases where you have to do some analysis as to how many people there actually are based now, how many people there will be, and what those percentages look like. Those kind of cases. But the way that I read the proposed rule, there wouldn't be any limitation on the regional director in those cases choosing that closing briefs are important and necessary, and issuing that for those cases, those kinds of decisions those kind of arguments can be provided after the fact.
So let me understand you. You said that in the majority of your cases, you don't file the post-hearing briefs?
That is correct.
Okay. Has it been the case that has it been your experience that the regional director has not been able to discern what the petitioner's legal position is relative
I think that the regional director is able to determine what our legal position is because we're asked at the end of the hearing to state what our position is for the appropriate unit, and given an opportunity, I've been given the opportunity to do an oral closing on the record where I refer to the leading cases on whatever the issue is that we're discussing at the time.
I see.
That was my question as well. Do you feel your position was misunderstood or compromised because you didn't file a written brief?
I don't think so, because I think that the readers of the record are fairly careful in making sure to go back and really determine what it is that they're looking at, getting beyond I don't want to say exaggeration or hyperbole, but it kind of is, of counsel, right? We're hired to be the advocates. Their job is to read it and determine what actually is going on there, regardless of how I characterize the evidence or how someone else characterizes the evidence.
I'd like to get back just briefly to the decision and direction of election. And do you feel that the fairness of the election would be compromised if the decision came out later?
I don't think so. And I'm going to go back also, in this case, to the issue that we see in arbitration. Arbitrators issue bench decisions with more complete written decisions to follow. And that actually provides more certainty to the parties because they know faster what's going to happen and everyone knows what to prepare for next. Even if they might not know the rationale, they know where that decision is.
A couple things on the briefing piece of it. Let's just assume, and put yourself in the shoes of the management attorney for a moment, and they have the sort of 12-factor supervisory 211 test. They have the burden of proof. They have to show specific examples of the authority existing. They have to show responsibly to direct, that there'll be some consequences. They have to show discretion, and it can't be a conclusory showing. And let's say you have 4 or 5 of those employees at issue, and you're going through it, one at a time because they're different supervisors, and you throw a few other issues in. I realize, because I have great admiration for union attorneys, because typically you all walk in with very little preparation, very little access to the documents, only talking to witnesses 1 or 2 times before an arbitration, and you can pull it all together. But when you have a document-heavy case where you have the burden of proof, you have all these different prongs of tests, is it really fair to expect an attorney to walk in and be able to build a record, make a convincing case to anybody?
I'm going to say yes. You have I
thought you'd say yes.
There's no point in time where the evidence is fresher than when you've just heard it. That is the moment when you've heard all of this. And most attorneys who do oral closings during the course of a hearing say, oh, this is what he said. I'm going to put this down in this spot right here because I'm going into my closing as a point that I want to highlight because it really shows how it addresses points 2, 3, and 4 of the supervisory status test.
But what if you have to have 20 or 30 documents you have to talk about interchange between locations, community of interest factors, things like that? Can you really have all that spiraling out in your head? So then it just emerges like Athena. Boom, here I am, perfect brief, perfect argument.
There is a trade-off between perfection and speed in some of these cases. But I'm not sure that perfection is what's necessary. Perfection is what delays us. And perfection in writing the brief is not the same thing as getting it right on the decision. And getting it right on the decision, the regional director has the time that they need from the record to pull all of that together. The jobs of the advocates is to highlight those issues so that the regional director knows what they're looking for in the record.
But isn't there a correlation between quality and due process?
Not necessarily.
Okay.
And whose documents are they?
They're always the employer's documents in those cases. The union doesn't have those documents in advance.
And whose burden is it if it's, say, a supervisory issue to establish what is being asserted?
Most frequently the employer. Every once in a while the employer will say that, we'll put it the other way, say our unit is incorrect, and then we have to defend our unit because we want someone out and they say someone should be in. But most frequently it's the other way around, where the employer says that our unit is overly broad and includes supervisors, and since they are trying to remove someone from the protection of that, the burden is theirs.
I see. Okay. Thank you.